this exciting session on deconstructing the legal nature of verified carbon credits. And I'm going to emphasize the term verified carbon credits because we're seeing a lot of other instruments in the market right now. There have been many issues throughout the ages on this topic, going way back to the negotiation of side agreements of free trade agreements, specifically the NAFTA. There have been incarnations from the UK Law Commission, and we've got a specific body in UNIDROIT looking at this issue right now. So why is this important? Why is this critical to everyone sitting in this room? I thought I'd ask Marcus Pullman from the World Bank just to give you a sense of the gravitas, why this is so important, and why it's coming to a head right now. Marcus, do you want to give us a couple comments?
Yes, so I work in the legal department of the World Bank. I've been working on carbon markets for the last 17 years, and one of the reasons why we have asked this great panel to address this issue at I4C is that, as you know, we in the bank, we are trying to promote carbon markets. We try to have carbon markets grow. We are helping many client countries to develop programs, high integrity climate programs. But on the other side, we are also looking towards letting the demand side for these carbon credits grow. And so we are looking at what are the expectations of potential future market participants on the buyer side. And we have been looking at many issues that de-risk programs from a project level, also from a non-permanence level in the forestry sector, etc. But one of the issues also from the angle of being able to transfer full legal and beneficial ownership of these credits that are being generated in our host countries. But one of the legal issues that has not really gotten into the spotlight so far, but which we know is very important for private sector investors that want to invest in these programs is what is exactly the legal nature of these verified emission reductions that we are generating in our host countries, and why is this important to grow the demand side, especially on the private sector? And that's why I'm very pleased to have this panel today, and I'm very excited to hear what everybody has to say. Thank you.
Thanks so much. And I just want to tell all of you that as we go through, Marcus will be going around with the microphone, so get those questions ready. It's very rare that you have 4 lawyers able to give you free legal advice. Of course it's not legal advice, but there you go.
Definitely not legal advice,
no,
to be clear.
Right. So let me just ask you a general question, and I'm going to start with you, Peter, if I can. Dr. Peter Werner, who's Senior Counsel with ISDA, the International Swaps and Derivatives Association. So why is this important?
Why is it important?
From your perspective.
Yes, thank you, and thanks to World Bank for inviting us. So this is a very crucial topic for us as a trade association that develops the transaction documentation that is being used for various types of asset classes, including VCCs, lately, and emissions allowances and similar environmental products. And we got into this debate a couple of years ago when the policy discussions were in full swing at the level of TSVCM, for example, that resulted in calls on industry to develop what they called at the time general terms and conditions to make trading in VCCs happen. And so that's one of the main jobs that a trade association like ISDA does. So we started looking into this and started developing documentation that has been published in the meantime. IETA have done something similar as well. So these processes were conducted in parallel. And that's all nice. We have produced these documents for, in the ISDA case, for physically settled spot, forward, and option transactions. But that's that. So people can trade on these standardized terms nowadays. The other topic that was identified early on in the discussions was, yes, we can trade those, that's fine, but what is actually the thing that you're trading? And why is that relevant? And that's the other key concern that ISDA has when it comes to providing documentation is, do these transaction types fall within the legal framework of the various jurisdictions around the globe that are trading in this, in terms of primarily their insolvency law treatment and also the treatment in terms of security interest, so property law usually. And we started looking into what the case might be in various jurisdictions with respect to VCCs. And lo and behold, the analyses that we got back were sort of all over the place. So people didn't really know what the thing is. It's not like any other asset class. And so therefore, we thought it needs to be established at supranational or global level that there are some guidelines for countries and legislators to legislate for the legal nature of VCCs. And these are topics that are also relevant to other types of environmental products going forward, biodiversity credits, all these kind of things. Anything that's really dematerialized, but particularly in the environmental space. So we need to know, from an ISDA perspective, what the legal nature of the VCCs are in each of the jurisdictions in order to be able to produce legal opinions. That's the other big job that ISDA does in the market, that the market participants can use vis-à-vis their regulators to prove that they can do these transactions. And in particular for financial institutions, I don't want to go too much into this, but it's for regulatory capital purposes. And with respect to VCCs, there was no clear view anywhere. We have done a study at the outset of comparing 6 jurisdictions, and the feedback was, as I said, a little bit unclear. In some countries, to be fair, it was clearer than in others, but not great. So therefore, the idea came up to go to an intergovernmental organization, UNIDROIT, who have experience, decades of experience in providing guidance in various forms of instruments for countries worldwide to establish a sound legal framework for property. I just want to, for VCCs, be that property or something else. There is a certain preference, we can talk about that, but some guidance so that the countries know what they're doing. And that's my last point, in particular the countries where the projects generate the credits. Because if at the outset of the chain of trades, the project where the credits come from, if the, say, property status is not clear of what the thing is, you can't really sell the thing. Because what you don't own, you can't sell. And that has big repercussions down the line of trading, in particular in secondary markets, where all the liquidity is supposed to come from. Because we don't want to find out at number 8 in the chain that at some point earlier, somebody actually didn't have the right to sell the credit that you obtained. So that's, in a nutshell,
so putting it really
from.
bluntly, what is the it that you're buying and selling?
Yes.
And we started with the question at ISDA. You got many answers, and then it went over to you, Mei Ling, to UNIDROIT, saying, what is the it? And so let me introduce you to Mei Ling Wang, who's the Principal Legal Officer and Co-Director at the International Institute for Unification of Private Law. In French, UNIDROIT. So tell me what you're up to.
Yeah. So Peter has mentioned that we got this proposal in 2022. We all know that the international instrument is very important to build a reliable and also well-functioning VCM for the market, and to reduce the investor risk, and also to help all the participants enhance the confidence. that with this proposal, thanks to ISTA, we got the support from many governments, and then with the support also from World Bank Group, we had two consultative meetings and got a very positive feedback. That's why last year the Governing Council authorized us to establish a working group together with World Bank. And so the working group was established last year. It's composed of 16 members, and we got also 26 institutional observers and 12 individual observers. And then we are also in progress of setting up a consultative committee. I think our instrument will be, as you can see from our website, will be a set of soft law. We have convened 3 working groups and also several intersessional discussions. What we prepared till today is 12 principles and a commentary. So what we have done, I think, is our aim is to help the participants of this market to understand better what VCCs under the private law. So that is our aim, because as you know, UNIDROIT is an international, independent intergovernmental organization. Our mission is to modernize, harmonize, and coordinate the private law and commercial law. So that is a very general overview.
Thank you so much. Leanne, let's go to you in the trenches of transactions.
Yeah.
Why is the legal nature of verified carbon credits important from your perspective?
Sure. So Linklaters were lucky enough to assist ISDA with the initial white paper on the legal nature of VCCs, and that was really an exploratory exercise to try to gather thoughts from the market, and also subsequently drafted the definitions and assisted IETA with the trading documents. So what struck me with that exercise was that it was very evident that there were lots of really great initiatives in the market, and there still are, of course, around this market, but very clear legal uncertainties. And as Peter mentioned, across multiple different jurisdictions. And actually, before coming here, I caught up with colleagues in other jurisdictions to see if, from their perspective, anything had moved on. And the answer is still very much, no, it's very difficult to categorize what a VCC is. Now, clearly that did not hold up getting the trading documentation in place. Both the ISDA and the IETA documents were published. We understand that they are very widely used, and that's fabulous, exactly what we wanted, to have some liquidity in the market and some standardized documents. But here's the thing, from my perspective, I don't think that's quite enough, because it's great to have the trading. I think we could have even more of that if we had a very firm view, or at least a firmer view on what kind of asset a VCC is. But we need to look beyond just the trading. And what I'm thinking here is the wider structured transactions, which can be really, really helpful for bringing in the money that we need for this market. So if I compare with the compliance market, I work on and have worked on for maybe 7-8 years, for a long time, on transactions whereby you would take a carbon credit from the compliance market, so an EUA, UKA, something similar, put it into a special purpose vehicle, essentially repackage it, issue debt securities to an investor who perhaps wants access to the value of the underlying, and then have a real life corporate entering to a forward on the other side so that it can hedge its own obligations. Now, the motivations for the VCC market will be very different, but you could see how this could very easily lend itself to a type of structure whereby you are issuing something like a note in order to get money in to fund the underlying projects. And that's a very well-known way of achieving funding for the kind of investors in the private market that we would be looking at. But here's a big problem with that structure. When we have anything like this, as a lawyer, my job is to sit down, draw out the structure, look at the pinch points for my clients. So where is the risk? And the big point here, fundamental, you need to have really good, robust security in these kind of structures. There is no getting away from that. When we look at the sort of nature of the projects, it's fundamental that you have that security in place. And as Peter mentioned, that is one of the things with VCCs, that until we really understand the legal nature, we can't properly understand, are they capable of having security granted in respect of them? Where is the right jurisdiction to do that? And I think until we get to the bottom of some of these fundamental issues and questions, we're in a way limiting ourselves in terms of what the market can achieve with some of these transactions. So I would really like to see these questions answered so that we can expand the scope of what VCCs can be used for and can access funding through.
So really important to really realize the value.
Absolutely.
Perfect. Simon Poulston Stones, who's a consultant with Philip Lee, again, from the trenches. Why is this legal nature so important?
So perhaps if I explain my perspective, first of all, I'm here on behalf of Philip Lee, the law firm, and we do a lot of transactional, regulatory, and legal advice, specifically in the context of carbon markets, including Article 6. I'm also a broker. I have a brokerage business, and through that business, I've helped a number of governments try to source corporate buyers for their IPMOs under Article 6 so that they can drive capital into their country. So I'm going to say some of the things we've already heard, but in a slightly more visual way. Marcus was keen that we be very visual and try and keep it out of legalese as we explain why does this topic matter to the audience in the room. And many of the audience will be governments wondering, well, why do we need to clarify this in our laws? So if you imagine I'm a project developer in your country, you've been wondering, why on earth is this here? This is a carbon credit that has come from my project that I'm developing in your country. And you've written me a letter of authorization, which enables me to sell these carbon credits to an international buyer. So if I'm the developer, the question, of course, is who's the buyer? Well, the answer is one of you is the buyer. There you go. Need to work on my throwing arm. Great. So I've transferred my credits, my IPMOs, to our buyer in the second row. Have I? I mean, do I have the ownership of the credits that I've just sold to you? Do you now have ownership of those credits to the exclusion of everybody else in this room and outside of this room? As I created those credits, I needed to develop a project, first of all. And to do that, I probably needed to attract project finance. And the institution providing that project finance probably said, well, what collateral am I going to get? I'm going to give you 10 million, you're going to develop these credits. What collateral am I going to get? And part of the answer should be that we can use carbon credits as something that is capable of having a security interest granted over it. But to Leanne's point, you actually have to understand what it is in order to work out, can I grant security over it? And also, at the moment, the way that the market works is these projects are typically financed through a forward sale of carbon credits. It's not very efficient. What we really want is to be able to access wholesale debt markets. And to do that, you need to be able to take carbon credits as collateral, ideally, so that through securitization, the process Leanne was talking about, we can tap new pools of capital to drive billions of dollars of climate finance into your countries so that more projects can be developed in your countries, bringing jobs in your countries and achieving the climate goals of your country and the Paris Agreement as a whole. So that's why it matters. It also matters not only for taking security and for trading, it also matters for insurance, which is an increasingly relevant factor, including for the World Bank under MEGA. If you have something in relation to which you're insuring, you need to make sure that actually you have an insurable interest. And to understand, do you have an insurable interest, you need to understand what it is that is being insured.
So very, very simply, you want the it to be certain enough that you can get a loan for it and you can get insurance
and that
for
I can
it.
sell it to you to the exclusion of anybody else.
Perfect.
And maybe just to add to that, because I think that's a really great point, Simon, in the transactions that I tend to look at, investors are super interested in putting their money into this, but they do expect to see that wrap. They do expect to see insurance or a guarantee, however you want to. That's a whole separate conversation as to how you define that. Oh,
Is that a fire alarm? Or?
this is exciting.
Okay.
We told you this was important.
Definitely, or?
So the worldwide Apple or something?
Oh dear. This is the equivalent to it going off in the gym when you're in the shower or something.
There we go.
Yeah.
Shall we try and muscle through?
Yeah.
Why don't we try and work through it? Sounds as though it's diminishing right now, and hopefully. Yes.
Yeah.
It's a German thing.
It does sound like it's diminishing, so shall we? Because we needed to emphasize the importance of the legal nature, you all got a warning for just how things can go wrong and what the siren sounds like when things go very wrong in a transaction. So we'll try and go through. It does sound like it's diminishing right now. We're going to do a rapid round of questions. We had talked about having a secondary commenter. I think we'd like to get to our audience for questions. So we're going to very rapidly just pose one or two questions to the panel and come to you. So get those questions ready. As I say, it's very rare that you have access to such talent in front of you. So let me start with you, Mei Ling, in general. UNIDROIT has done an issues paper and draft principles.
Yeah.
What specifically is the UNIDROIT project targeting in order to enhance that legal framework, enhance the market confidence, and really get cross-border transactions and verified carbon credits going?
Yeah, thank you very much. So the goal of this international instrument is to provide a comprehensive and consistent legal framework across different jurisdictions, whether they follow common law system or civil law system. So our instrument aims to reduce this legal uncertainty, and till today we have already have a draft of 12 principles and a commentary. So, okay.
Sorry, Mei Ling.
Sorry.
I'm so sorry.
This is a high priority project in UNIDROIT in these 3 years. So I'm going to break down this instrument in 3 main parts. The first part is the introduction part. And we got this introduction part to introduce the life cycle of VCCs, because I think this part is really important because the life cycle of VCCs involves numerous global transactions and cross-border transactions and activities.
Let me just interrupt for a minute. This is a metaphor. We went from chaos to UNIDROIT, providing certainty and calm to the market.
Yeah. And then the second part is the clarifying of what is a VCC. So from the principle 2, we can find out that we have defined the VCC as an intangible asset. And so that is principle 2. But the most important part is from principle 4 to principle 12. We discussed the key points of VCC transactions from insurance and then reversal, revocation, retirement, registry, transfer, of course, and retirement, security, custody, and insolvency. So I think they are three parts of our instrument. The aim is, as you said, that to reduce this legal uncertainty.
Very important. There are a number of negotiators in the room. Kazu, I'm looking at you. And I think that issue around revocation is hotly contested in the UN negotiations, so really good resource for many purposes, not just the transactions themselves, but also for negotiators in the room. Simon, let's go to you on the issue of where we've come from. We've got the Law Commission in the UK taking a top-down approach. And the outcome of that was 5 simple lines of recommended legislation, and then we have the UNIDROIT approach. What's better and why?
So what are the pros and cons? Well, hopefully from my teddy bear, you got the important thing is to drive capital into your country to be able to create jobs and for you to achieve your climate goals. And as you alluded to, Lisa, uncertainty as to the legal nature of carbon credits and whether you can create security over them, uncertainty is going to kill your ability to be able to attract finance into your country and develop these projects. So that's why it matters. So what the Law Commission in England and Wales have sought to do is to bring some more certainty around the legal nature of, largely they were talking about digital assets, but within that paper they were also looking at verified carbon credits. And then you have UNIDROIT with a very bottom-up approach. So what I liked about both approaches is it was very consultative. So you have experts on your working group, both professors at universities, and you have market participants. With the Law Commission, they had working groups, and they had papers, and they had consultations. Unfortunately, the Law Commission of England and Wales's approach is a missed opportunity, and I encourage those governments in the room not to make the same mistake. Why was it a missed opportunity? Because they spent over 500 pages analyzing these legal questions. And all that matters is the output, the so what. The output of the Law Commission's approach in England and Wales was 5 lines, and those 5 lines said, there's a third type of personal property under English law. Now, I don't think any of you, as a result of what I've just said, are any the wiser as to whether a verified carbon credit is or is not in that bucket. What does it mean if they are? And they concluded that that's literally all we're going to say, and we're going to leave it to the courts to work out, is a voluntary carbon credit property in the first place? Or is it capable of attracting property rights in the first place? If it is it in this bucket of the third type of property? And if it is, what rights attach to that? Now, the Law Commission's approach has been to draft legislation that just says there's a third type of property. They could have brought certainty to the market by literally adding one more sentence. Verified carbon credits are a third type of property, full stop. That's literally all they needed to do. But they decided, in their wisdom, they will let the courts decide. That will take decades. Don't leave it to your courts to decide what is the legal nature of a carbon credit. Do what UNIDROIT is recommending. And one of your most important recommendations is that as governments, you specify in your legislation what is the legal nature of a carbon credit. Once you've done that, I can sell a carbon credit. Once you've done that, we can grant collateral and security interests. We can access wholesale debt finance markets. We can create jobs in your country. So be specific. And what I like about the UNIDROIT approach is it recognizes that all the different governments in this room have different approaches to law. Some might be common law jurisdictions, some might not. And so they're taking the approach of not being utterly prescriptive and saying, thou shalt all have the same law, sign here, but recognizing that you all have different approaches. They're creating principles. And do please have regard to the UNIDROIT principles,
like a guidance,
which you then implement in your own legislation. And why do we want that? Because we want to encourage international consistency so that we're not having to get used to nearly 200 different jurisdictions of laws to work out what is a carbon credit, but by and large, you all do it the same way, in alignment with these principles, respectful of your own national approach to law, but try and remove that uncertainty by specifying what it is, because that way you'll channel climate finance into your country much more effectively.
And just following up on one of your points, leaving things to the court or to international arbitration doesn't always work out as anticipated. We've had a recent ICSID decision that was, I don't think, what either of the parties. It was Koch brothers versus Canada, and I encourage you to look it up. Leanne, we're going to go to you, and we're going to take another 2 minutes each so we can get to your questions, so get them ready. From the trenches again, how might this legal nature affect market transactions?
Yeah, and that's a great question, because I think sometimes people find it difficult to understand why it does matter. And to Simon's point, the kind of fragmented approach globally isn't super helpful here. So under English law, EUAs are treated, for example, as intangible assets, so we could probably get comfortable that that would be similar with a VCC. Whereas in other jurisdictions, you might be looking at a VCC as a bundle of contractual rights. And the reason that is important is because the way in which you transfer a contractual right is very different to the way that you would transfer an intangible asset. So it's perfectly doable, of course, but we need to make sure that we're transferring things in the right way. If you have contractual rights, you have to assign, you have to novate. There are additional hoops that you need to go through. And so just to pull out a few of the really important things that will be impacted depending on where we land. We talked a little bit already around title of transfer. If I were to buy some VCCs from Peter, I want to make sure that he is able to sell them to me, and that's the end of it. I do not want to have to go back through the whole chain to see if he were entitled to hold them to begin with and whether I was now holding good titles. So that starts to manifest when we think about things like fraud. You know, if there's fraud and we don't understand what the legal nature is, it's very difficult to start picking apart, you know, who should have held the title. Insolvency has been touched on. That's a really big point for transactions, because thinking about any kind of typical transaction, even if it were just a secondary sale, you have a number of counterparties who may go into insolvency proceedings. You have a project which may unfortunately go into insolvency proceedings. And we need to be absolutely sure as to what the relevant jurisdiction is that we should be looking at here. That's an absolutely fundamental question. And then security, I talked a little bit around security already, but we need to make sure that we are comfortable that a VCC is capable of having security granted over it. So in the UK and in most European jurisdictions, typically you would look at where an asset is located. That isn't the case globally, but that's typically the rule. So what does that mean here? Would we be looking at where the registry is? You start to have different layers in terms of where you need to take security. And I think that's quite an interesting point there, because that is an example of where it also becomes jurisdictional. Because even if we work out what should be the legal nature of a VCC, different jurisdictions may look at this in a different way. And we see that with EUAs as a good example. EUAs are treated as an intangible asset. They are capable of having security granted in respect of them. However, some jurisdictions, the Netherlands being one of them, has actually implemented legislation to say you cannot grant security or you cannot pledge EUAs. So it's not quite as simple, unfortunately, Lisa, as just saying, if we work out the legal nature, everything else flows. We do need to be aware that there are these secondary jurisdictional questions. And so much as I'd love to say we'll reach a brilliant global agreement as to what needs to be done, I think we need to just bear in mind that there are different elements feeding in.
I know that there will be many comments on that, but let's just pop into Peter first, and then we'll open up both to the audience and to the panel to ask and comment on those related issues and very critical items that you bring up. So Peter.
Yes, so
to get money flowing,
exactly.
That secondary market's important.
Indeed. So we've established market-based approach is great. So we want to get trading going. Legal nature is one fundamental issue, but there's a couple of others that people should keep in mind, in particular when you are in jurisdictions trying to develop a capital market that includes carbon as an asset class for trading. So most of those that I wanted to mention to you in a second are of a non-legal nature. So for example, if the role of financial institutions is going to be big in this type of market, the regulatory capital treatment of carbon credit needs to be clarified. That's currently still pretty punitive. It applies to several sort of new asset types, but it applies to carbon as well. So that needs to be dealt with and is being addressed, but keep that in mind. So it's not that the market will miraculously appear just because we have provided guidance on the legal nature. That's one element. Others need to be looked at too. The second one is the accounting treatment that goes with it. It's also not really clear. Leverage should be made of rating agencies in the space of carbon credits as well, in an organized and well, harmonious fashion, I guess. There are obviously issues around the environmental soundness and the scientific value of carbon credits. That's sort of beyond our remit here anyway, and certainly of ISDA's remit. But obviously, that's a big factor in terms of gaining increasing confidence in the market. I would like to mention two more things. One is non-legal, the other one is legal. Global identifiers for these credits and the system around them should be harmonized too, just like in any other asset class. It doesn't matter which one necessarily, which approach, but a unified one. That will help as well. And then the final comment I would make is sort of a legal nature. Financial market infrastructure has existed for trading in intermediate securities, for example, for ages. Custody arrangements are all based on sound legal frameworks. And when we talk about transferring credits from A to B, might it be helpful to consider the use or the increased use of existing financial market infrastructure, something similar to a CSD, for example. Also because from a regulatory perspective, these are properly supervised. There are rules established around the insolvency of those, for example, which would help here. Because what we currently have in the carbon markets, which is sometimes referred to as a registry, is a transaction log. None of these registries record encumbrances over these credits. They just record a transfer of this or that credit has taken place from A to B. They don't want to deal with anything beyond that. So in order to address the security interest issue in an efficient way, there is something to look at in the world of securities trading that might be worth considering for this type of market too. So I'll leave it there.
A lot to consider there, not the least of which is not just what is it, but how is it treated as an asset? Is it a liability? Is it a contingent liability? And how do we actually hold these things? I know we have one more comment, Simon, that you wanted to comment on something Leanne said. So I'm going to ask Marcus at the same time. Oh, my goodness. We've got 2 questions here in the front. Why don't you start very quickly, and then we'll go to our questions in the front.
And just what you were saying a moment ago, one of the issues is you can't, when you look at the register, and the credits are in somebody's account and there's a name on that account, doesn't mean they own it. That's the problem, right? And it doesn't mean they haven't granted security over it. You can't tell. That's the problem. But on Leanne's point, I think the other thing that perhaps we should communicate for this audience, again, why should you care if a transfer of credits from a buyer to a seller is invalid? Because you're making corresponding adjustments under Article 6 of the Paris Agreement. And if it turns out that a project developer in your country sold credits in the form of an ITMO that was authorized under Article 6 to a buyer in another jurisdiction, and you wrote a letter of authorization saying, we're not going to include that in our NDC, so that eventually perhaps a buying country can do that. But if that transaction is invalidated, how do you unravel that within Article 6? How do you undo a corresponding adjustment because the trade was invalid? Paris Agreement doesn't cover that.
And the timing.
And the timing.
3 years to actually make, at least 3 years to actually make a corresponding adjustment. How to unmake a corresponding adjustment. There's a question here, there's a question there. There's a question 2 at the back, 3, 4. I'm so glad we left time for questions.
Nice, yeah.
I'm going to actually take 2 questions at a time so we get to all of your questions, if that's okay.
Yeah. Good morning. My name is Alexander. I'm with I4C, part of the World Bank Group. Thank you for this very interesting discussion. Two quick questions. One is, I think 2 years ago, the volume of the voluntary carbon market was about $2 billion. Now it went down to about 700 million. So if I understood the gist correctly, there's no solid legal basis behind this market. You know, this is the volume of $2 billion, you know, $700 million. So you're saying that legally, strictly speaking, it's not fully kosher? And
not
the second,
quite saying that.
Okay, and the second question is, would you say that from the legal standpoint, carbon markets are sort of similar to derivatives, maybe in a sense, call options would be close to it? Or, thank you.
So I'm going to go to the next question. So we've got one on the value of the market and what's underpinning it. And secondly, the derivatives question. Right behind you, there was one, Marcus, a gentleman with white hair right there.
I'll do just...
Okay.
Thank you. Hi, my name is Sangeet. I'm from Climate Focus. I'm not a lawyer, not a finance person, but from what I understood, it seems like there are two categories of legal nature for VCCs, so the contractual rights versus intangible assets.
Versus perhaps X other, which we're not sure what that is yet.
But from the perspective of a project developer, an entity that's trying to develop a project and get a loan, for example, is there a preference for one or, you know, what are the implications of having one versus the other vis-a-vis ease of immediate financing for the activity?
That's a very complicated answer. Why don't we go this way? We'll start with Simon. We'll go through, pick the question that you want to answer. I'm going to hold you to no more than 1 minute each on those answers so we can get to these other questions. Do you want to start, Simon?
On the I4C's question, is the market built on sand legally? There's a yes-no answer to that, which is I think that the market has evolved over time, and what we're trying to encourage collectively is an increase in legal certainty to address the current uncertainty. So it's not that there is no legal underpinning, it's just that that legal underpinning may not be crystal clear and there may not be consensus, and there's an opportunity, therefore, to clarify and bring certainty. Is a carbon credit a derivative? So I was a structured finance and derivatives lawyer for 15 years before I ran a derivatives trade association. And that, when I first saw carbon credits, I thought, surely this credit is something, the value of which is derived from something else. That's a definition of a derivative. So is this a derivative rather than property? I think at the moment where most laws are going in most jurisdictions is, no, that's not the correct interpretation. The correct interpretation is it's something in relation to property, in relation to which property rights attach. That being said, you might be trading carbon credits, not only selling on a spot basis, but on a derivative basis, i.e. forwards and options. And that forward or option transaction in relation to the credits would be a derivative transaction.
I'm just going to ask Peter to jump in on that. Differentiate between the primary and the secondary market for the crowd.
Yes, so we are talking about, so primary markets in terms of terminology, we see it, this is the project side. The secondary markets are the markets that happen beyond the initial offtake of a credit from generated by a project. That can happen on a forward basis, do it spot and retire immediately, but the secondary market is based on the assumption that these credits do not get retired immediately, but sold on. And that's where the liquidity is supposed to be generated going forward. So that's our way of seeing this. Maybe one comment, if I may, on the volume question. Not sure. I don't think it's because of the legal uncertainty that's been identified here. It's because of other factors. But the aim here is to scale this market. And 2 billion isn't great. So if this is supposed to be scaled, as everybody wants, and the policy decision is clearly in favor of a market-based approach, this needs to be clarified, the legal issue, because otherwise no other players will come in. That's the point. And therefore, the knock-on effect will be in terms of the development finance that is being generated by this towards the generating countries in the global south, for the lack of a better term, won't happen either. So I guess we are just highlighting this, the project here highlights an urgent issue which wasn't as prominent because the volumes didn't matter, frankly.
So Mei Ling, I'm going to ask you to jump in on the second question. We've had relative answers to the pillars of sand and the derivative question, but there was an assumption that there were only 2 legal characterizations in the second question. Do you want to address the potential realm of possibilities?
So I want to give a feedback to the first question.
Sure.
Because this gentleman asked the ground of this market, so the support of this market. I think from very beginning of this society, 2,000 years ago, we don't have any law. When we have our society, we have our economy. So I think sometimes the market comes first, then we have this law to support and also to enhance, to develop this economy. That is right. So this is from very, abstract angle to answer this question. And what we're doing that, even before we didn't have these specific principles or legal instrument. We have in each country we have contract law, and also we have international commercial laws, so to resolve the specific problems, legal issues. And what we're trying to do is that since we are very confident to this market, so that's why we're setting up a soft law, not like international convention, the binding, blending, inventions, but rather than a guidance of a legal framework to give a market, all the market participants a very good, clear understanding about all the transactions. That is. Yeah.
Perfect. Leanne, what I'm going to do is I'm going to go to the next question. You can choose whether to weigh in on the prior questions or weigh in on the next question.
Show. This is great, isn't it?
Marcus, where are you? Oh, here we go. Here's the question. Go ahead.
Hi, my name is Jeff Berman. I'm from Expansive. The registry, I think, is actually very important here because it's more than just the transaction log. It remains that single source of truth for what is going on. And it's also where the asset or the instrument, whatever you want to call it for this, is ultimately created. But, and the sponsors of those registries can be for-profit, non-profit, or public sector, both in the voluntary market as well as in the compliance market. And I understand why this is so critical, and especially kind of defining what it is that we are buying and selling, but shouldn't so much of this be answered by just the terms and conditions that an account holder signs when they join the registry?
So I'm going to go to Leanne first, if you want to take that one, or you can address the other one. And then the mic should go to, we have many. 1, 2, 3, 4 here, 5 here. Go.
I'll make a start on this question, but I don't necessarily feel I can answer it, so maybe everyone could jump in. I think that is, if we could just get around all of this by having the terms and conditions be able to deal with it, I mean, that would be great. I agree with you. I think that the registries have a really important part to play here. And one of the difficulties is, as you'll be aware, they all have slightly different terms and conditions. And so you're adding another element. I'm hesitant to use the word cherry picking here, but there's another thing that you need to think about with all of this. One of the big things that comes as a consequence of the legal nature is fungibility. So can you transfer something from one, if I have a Vera account, can I transfer to gold standard? Well, actually not at the moment, that isn't possible. But if we had these terms and conditions that were perhaps a little bit more aligned, would that be possible? So I don't have the answer to that question, but I think it's a really important point. I'd be interested to hear whether anyone had anything to add to it.
And just, of course, terms and conditions can't supersede sovereign rights and laws.
So I think that's the point. It comes back to what we were talking about earlier, about whether registries are just tracking a credit went from account A to account B, or whether the fact that they're in account A to start with means that that is the definitive point of truth as to who the legal owner is. And at the moment, that is the case, I understand, for Puro, but that isn't the case for Gold Standard or Vera, both of whom prohibit account holders from granting security over the credit that is in their account. And so in an ideal world, the way that you treat carbon credits like the first type of property, and like real estate, where I own my house because the land registry says I own my house, and the registry is the source of truth. But in financial markets for equity and debt, it doesn't work like that. And so instead, you have to say, well, if there was a failure in the transfer process such that the principle we said earlier was I can't give more than I have. Okay? There's an exception to that, which is if I'm an innocent purchaser, I didn't know that there was some flaw in your title, then that is where UNIDROIT is currently going as the answer to addressing that problem, is relying on established legal principles. So yes, there are shortcomings, and the register doesn't typically solve the problem by being that source of truth, because as you said earlier, the law will override whatever your terms and conditions say, and they sit within that context.
So I see we are at time right now. I'm wondering if there is any flexibility, because I see we have 5 more questions on the timing, but I'll look to the back of the room to tell me if that's the case. And alternatively, I'm going to take moderator's liberty here, and there's a question at the very back of the room, and there's a question 3 up, and we're going to ask them, and we'll go from there. If we can have a succinct answer. Who's got the mic? Why don't you just stand up and ask the question loudly?
Hello, my name is Aisha from Energy Changes Project Developers in Austria. I'm very happy about the session for 3 reasons. 1, I feel like I have 5 lawyers here for an hour. I've got my money's worth, so thank you. 2, 3 women on the panel. Thank you. I forgot the 3rd one. I'll come back to that. So my question is, I know it's a VCM session, but how much of this uncertainty you're talking about can be put into the Article 6 rules and operationalization? And if there is a possibility to do that, is that taking place in the negotiations?
Very, very briefly, public law versus private law. Right? Paris Agreement is public law. The stuff we're talking about is private law, i.e. the laws of contracts and so on and so forth. So the challenge with the Article 6 markets is you've got a hybrid of what we've been talking about. So if you're doing a cook stove project in Tanzania and you're trying to sell that as an ITMO to a buyer in Europe, on the one hand, you're having to ask all these questions as a matter of private law in the relevant countries, but then you're trying to ask the public law question of where does this all fit within the Paris Agreement? And so it's a complex question with a complex answer.
And different legal traditions that will not be dictated to or have their sovereign rights affected by a top-down international agreement on some fronts. I'm not going to go to another question right now. I'm going to go to the one here. Please stand up and ask your question. Just speak very loudly, please. There we go.
Moses Kato is my name, from Government of Uganda, Ministry of Energy. My question goes about the legal guidance that is currently available to guide the transition from CDM to Article 6 for ongoing projects. Do we have any at the moment that can guide that?
There's certainly a number of issues that have been in the transition from the CDM to Article 6.4, and the UNFCCC Secretariat has given some guidance. And there are a frequently asked questions page associated with the Secretariat's guidance in that regard, coming from the supervisory body as well. I'd encourage you to look at those. There are still chunks of uncertainty. Does anyone else have anything to add in relation to the transition from the CDM to the... we have 2 more questions. I don't know where we're at. Market, yes, no? Yes, 2 more questions here. Stand up and start asking while the mic is coming to you.
Thank you so much. So I'm Simone Weichenrüder from EBRD. I have specifically a question on Article 6, also touching on my colleague's question here. In terms of ownership and security of ownership, when you transfer between country to public to private entity, country to country, basically, ITMOs. What do you say is the current situation in terms of legal frameworks? What do you say? What do we need actually to make that secure and also secure transactions for like countries and private entities in that sense? Thank you very much.
We'll go to the next question, and you can wade in, should you wish.
Hi, this is Neeraj Mohanty from Core Carbonex. We are a project developer. My question is that when it comes to the agriculture sector productivity, number of productivity in developing countries coming up, where majority of the farmers, they get the emission reduction happen because of the one aspect is the change in behavior, the other aspect in the land. When it comes to the tenant, where the ownership of the land is not being defined very clearly, many of the farmer is working on a land which belongs to somebody else. How do you define the carbon rights? The carbon rights partly for the behavioral aspect changes, which is maybe emission reductions, the other aspect which is happening in the land, which may be increasing the carbon sequestrations. How do you define the
I'm going to intervene on that one, because that is a truly legal advice question that I wouldn't want to expose the panel to. In terms of the other question, does anybody want to weigh in on that?
Have to, yeah. Again, it's mostly a question of public law. It's mostly a question of Article 6 and where are the current gaps in Article 6 that can be solved at Baku, including can a government unilaterally issue an LOA, a letter of authorization, without there being a government on the other side. And we see different governments taking different approaches. And what does that mean if you've already bought an ITMO from one of those countries and it turns out that's not allowed anymore? Then there's a question around revocation. If the letter of authorization is revoked, what does that mean for the transfer that has already happened? How does that impact and feed through to the nationally determined contributions or your compliance with Corsair if you're an airline, et cetera, et cetera? So those are all largely public law Paris Agreement questions for solving at Baku. Please, Baku, not Brazil.
I want you all to join me in thanking this extraordinary panel and their frankness. Thank you also for your engagement, your questions, and I encourage you to follow up with each of them. Thanks for your patience. Appreciate it.